Hi, my name is Jeff Lee, and I'd like to talk to you about your Fifth Amendment right not to incriminate yourself. If there's one aspect of criminal procedure that most Americans are familiar with, it's that famous phrase that you've seen on television: you have the right to remain silent, and anything you say can and will be used against you. Now, even though most people seem to be familiar with that phrase and seem to understand the phrase, few Americans exercise that right. I'm going to talk to you in this video about what the penalty to the police is when they don't read you that right, and they should have. But first, let me tell you the two requirements for a Miranda warning to even need to be read. The first requirement for a Miranda warning is that you must be in police custody. That doesn't mean necessarily that you are in an interrogation room. It just means that you are in a situation where you would not have felt free to leave, and that any other reasonable person in the same situation would not have felt free to leave. As an example, if SWAT officers come busting into your house at 3 a.m., they're all armed, they've surrounded you, your children are crying, and an officer says to you, "Sit in that chair," and starts asking you questions, the court will apply the standard I've just mentioned, whether you would have felt free to leave in that situation and whether any other reasonable person would have felt free to leave in that situation, to determine whether you were in police custody at that time. Now, if you receive a call from a police precinct and they say, "Why don't you just come on down? We'd just like to ask you a few questions," or "We'd like to put you on a polygraph test just to rule you out as a possible suspect," that is not police custody, because you went to the precinct freely and voluntarily. Now, there are situations where you could go voluntarily and then it could turn into custody, but if you're in a situation like that, you need to call a defense attorney. The second requirement for a Miranda warning to need to be read is that you must be subject to interrogation. That doesn't mean that any particular heavy-handed interrogation techniques are being used. It just means that you are being asked questions by the police and that you are giving responses to those questions. As an example, if a defendant is handcuffed and immediately blurts out, "I did it," that response was not from a police question. It was just a statement that was blurted out. And that person cannot use Miranda for protection because he cannot show the court that he was giving an answer in response to interrogation. Now, even though in TV you see that every defendant is read their rights the moment they're arrested, in real life it's not nearly as common. For example, if the police are called out to investigate a scene for a possible aggravated burglary charge, they may go out there and see a suspect running out the front door with his or her hands full of items from inside the house. In that situation, they are not going to need your confession because they can testify with personal knowledge about how they saw you there leaving the house. So they will probably just arrest you and put you in jail. They don't need to interrogate you all night long because they already saw what happened. Now, there have been a lot of Supreme Court cases recently that have limited Miranda protections. And without going through each of them, I want to tell you what you need to know. If you are in police custody and you are subject to interrogation, the proper course of action, if you want to assert your Fifth Amendment right to remain silent, is to say, "I want a lawyer," and then don't say another word. If you say that phrase and then start talking again, you will have waived that requirement for a lawyer to be present. Now, police will often tell you, "This is our last chance to help you. You need to tell us everything now before your lawyer gets here." Remember, police officers are not social workers. Their job is not to help you. They don't go to all that time and trouble so that they can get you off on these charges. Their job is to investigate and prosecute crimes. If you're in a situation where you're in custody and being interrogated, you need to say, "I want a lawyer," and you need to get one so that a defense attorney who is there to help you will be present. I wish you the best of luck. Thank you.